State of Florida is now in session. Honorable Richard B. Orfinger, Chief Judge, presiding. All persons having business for this court draw near to attention and shall be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session in the 5th District Court of Appeal. Let me welcome everyone here and introduce the panel. This is Judge Tom Sawaya to my right, Judge Carrie Evander to my left. If you have a cell phone, we would appreciate if you'd turn it off so that we don't interrupt any of the parties while they're making their argument. We have 3 cases this morning. The civil cases will have 20 minutes per side. Criminal case will have 15 minutes per side. And we'll go straight through if the parties for the 10 o'clock case are here when we get to that one. So we'll start with the first case, which is ELVIS QUIMI. I'm not sure I'm pronouncing it right, versus State.
That is the correct pronunciation, Your Honor. Mauricio Webby on behalf of Mr. QUIMI.
Okay, good morning, sir.
Good morning. Good morning. If it please the court, I'd like to reserve 5 minutes to respond. Thank you all for your kind attention this morning. I am requesting that Mr. QUIMI be granted a new trial. I have submitted in my appellate brief. The argument is that there was fundamental error in this case. During the trial judge ruled that there was police misconduct that violated Mr. QUIMI's Miranda rights.
Let me ask you, I read the transcript, and it seemed to me that the trial court's primary concern was the fact that when they invited Mr. QUIMI down to the police station, he got in his own vehicle, drove down there. But the police officer had an arrest warrant in his pocket, so to speak. I don't know if it was literally in his pocket, but he had one. And his clear intention, I suppose, other than perhaps learning something extraordinary, was to arrest Mr. QUIMI, which in fact he did. And it seemed to me that the trial judge focused on the fact that the police officer had a warrant, didn't tell Mr. QUIMI until after he made some statements that are arguably inculpatory, that was the reason that he belatedly said, I would have granted a motion to suppress. I'm going to tell the jury to disregard that. Is that a fair assessment?
In a way, but I would distinguish that somewhat, Your Honor. The trial judge never says outright that that is the sole reason. He counts that. That's part of the testimony that he took, but what he really refers to is police misconduct. There's other police misconduct throughout that he was privy to. For example, the officer in this case, Officer Dillon, they had Mr. QUIMI in a room that was locked to Mr. QUIMI. He couldn't get out without the officer say so. And
well, I thought that the officer's testimony was that it was locked to go in. In other words, everybody had to be buzzed in or have the code. But Mr. QUIMI was told, and the locks, if you wanted to walk out, you could.
He could, but he would need permission. He needed permission in order to do that because they had to unlock the doors. In other words, it wasn't like everything was free access for him to leave.
I'll have to take a look at it. That's not the way I had read it. I thought his testimony was it was locked going in, but unlocked going out.
I would have to find it, Your Honor, exactly, but I know that somewhere in there in the record there is the issue that he needed permission to get out. He would have to be buzzed out. I've also got, while he's under these circumstances, the Officer Dillon tells him, and excuse my language, I'm not going to sit here and let you bullshit me and lie to me when I know the full story, and there's other reasons I know the full story. So Officer Dillon having him in that police station is challenging him and telling him that he's got other information and he's challenging him with respect to the evidence. I think that
What's the test? What, let's lay aside for a moment the fact that there was no motion to suppress filed, that the statement is made, and only, I guess it's maybe after the next witness, that the defense attorney says, Judge, I want to make essentially a retroactive motion to suppress, which not exactly sure how that works, but I think you concede that if it works at all, unless it's fundamental error, that you don't get anywhere. But let's get past that. Let's just talk about if it's error at all. So what's the test to determine in this situation whether or not that this was a Miranda problem?
Under these circumstances, looking at Lorenzo and looking at the other cases, it's a reasonable person. Would a reasonable person have felt free to leave under these circumstances?
And what do we examine in trying to reach that conclusion?
The record evidence shows that Mr. QUIMI, although he had gotten there voluntarily and he drove voluntarily his own vehicle, that he was in a police station where he would have to be buzzed to be let out, and that he was challenged by evidence that...
Well, what my notes say specifically is that he was specifically told that while he had to buzz into the interview room, he simply had to push the doors to leave. So there was no buzzing to get out. I mean, there's buzzing to get in, but all he had to do is push the doors to leave. So that's what my notes reflect. And he was told that.
I have somewhere in the record, and I'll have to get it momentarily.
Well, let's from my understanding of the case law in Florida is in determining whether a reasonable person, and I think we agree it's the objective perception, not the subjective perception. The reasonable person test, the Florida Supreme Court in Shuttleworth came up with a 4-prong test. And the 4 prongs are the manner in which the police summon the suspect to question him, the place, purpose, and manner of the investigation, the extent to which the suspect is confronted with evidence of guilt, and whether the suspect is informed that he's free to leave. So let's talk about the manner. They go out to him. He knows he knows that this woman has made some allegations against him, and the police are looking at it. They say, we'd like to hear your side of the story. Do you want to come to the police station and talk to us? He says, sure, I'll drive my own car down there. So that one doesn't seem to be a problem.
I agree, Your Honor.
So then we get to the second one. The place, purpose, and manner of the investigation. The place is clearly a police department. I guess we're having a little bit of a disagreement on whether he was locked in or was free to walk out. I mean, it was clear that the police were investigating him for a crime, but the case law also says that the mere fact that it's in a police station doesn't automatically turn it into a Miranda problem.
Correct.
Okay, then we've got the extent to which the suspect is confronted with evidence of his guilt. In this case, the police officer, as you just said, tells your client, this is what she said. We want to hear your side of the story, and then he says a few things, and the police officer says, don't pull my leg, basically. That one seems to kind of go, it wasn't, a friendly chat at McDonald's over a cup of coffee, but it wasn't the rubber hose treatment either. And then, whether the suspect is informed that he's free to leave. I mean, he clearly was told he was free to leave. I guess we're going to have to go back and look at the record, but whether he was actually physically free to leave, I guess we're going to have to figure out. So, I mean, do we agree that that's the test, assuming that we can ever get there at all?
Yes, Your Honor. Yes, Your Honor. We do agree on that. With respects to factors 2 and 3, the idea that just because it happened at a police station doesn't mean that necessarily Miranda is involved, sure, but that's a factor that can be considered. Sure. And so you've got here a young man who's 18 years old, virtually no prior record, but for a traffic offense, and in a police station, and being confronted, as the court points out, not in any warm manner. I mean, he's being told there by the people that are in control, don't lie to me, in very aggressive ways. being challenged with the evidence, being challenged with the idea that the police officers think that he is guilty. So I'd argue that under those circumstances, a reasonable person in Mr. QUIMI's position could think that he was not free to leave.
Let me ask you this. There was a recorded phone conversation between the alleged victim and your client, in which your client made some statements which were possibly harmful to his case. Would you agree with that?
The statements that he made were, he explained that he felt badly for the situation.
He said he made a mistake and regretted it and things like that.
It could be characterized against him, sure.
My question is, was there anything more damaging in his statement to the police than wasn't heard on the recording, which was something that came in and you're not raising on appeal? So was there anything worse in the statement to the police for your client than what was on the recording?
Well, with the statement to the police got to characterize it the way that they chose. And so they characterized it as outright admissions, even though...
But they were questioned on what he said, correct?
Beg your pardon, Your Honor?
I mean, they did give testimony on what words the defendant used.
Yes, but they characterized it as an admission, even though, that's the way they characterized it.
Other than the fact that they characterized it as admission, was there any testimony that came out that his statement to the police gave more information than what he said on the recorded phone conversation?
No, Your Honor.
So in essence, the jury heard something twice rather than once.
And I would put out that they did, I agree, Your Honor, except that they did characterize it as an admission.
Okay, it's hard to me it seems like it would be hard to find fundamental error, if there was error, if the jury could hear his statements one time with, where there's no issue being raised that it was improper for the jury to hear that. And it seems to me your argument, but it was wrong for them to hear it the second time in a different context.
Yes, Your Honor.
Okay. All right, thank you.
Thank
You've
you.
got about a little over 4 minutes if you want to go on to that.
Thank you.
May it please the court, counsel, good morning. My name is Kelly Nealon. I'm here on behalf of the state of Florida. It's our position that this claim is invited, it's waived. He made an oral motion to suppress 2 witnesses after this detective testified as to the statements that he made, and then counsel specifically said, I don't want a mistrial, I want a curative instruction, and that's exactly what the trial court did. So I don't really think he should be allowed to raise error in this manner on appeal. As far as fundamental error, it's fairly tough for that reason. There never was a motion to suppress hearing. The only facts that we have were from the detective's testimony. And based on that testimony, I think, yes, clearly this court could find that the trial court shouldn't have granted his lately filed oral motion to suppress. As far as the testimony, the detective testified, I usually say, with this, I have to buzz myself in. If you want to get up and leave at any time, all you have to do is exit. You have to buzz yourself to get in all the doors, but you can push them to get out. I made him aware that you're not in custody, you can leave any time. He was asked, basically not everyone can get in, but once you're in, you can get out. That's correct. You let him know he was free to leave at any time. That's correct. That's what the record says. There's no other contrary testimony. If this court doesn't have any further questions, then I would rely on my brief and ask this court to affirm the judgment and sentence.
Thank you, ma'am.
Thank you.
Thank you again for your attention. I have not had the opportunity, forgive me, to go through the record and figure out where that is. It may be an error on my part that I may have to concede, but I feel very sure that there was a portion in there where there was testimony that he needed permission to leave in order to get out. And that's all that I can offer at this time with respect to the court's questioning on that issue. Going back to what I had anticipated, I'd argue that absolutely it was fundamental error because there was no corroborating evidence for her claims. Please do keep in mind that there was no physical evidence at all, that the report was made a week after the alleged incident, that there is a witness who is present for the entire incident.
Well, let's discuss that, though. I mean, I certainly will agree with you that this is far from the strongest case I've ever seen. I mean, this is the classic he said, she said, except you've got him on the tape-recorded phone call making some arguably damning statements. I shouldn't have done it, or it was a big mistake on my part, something to that effect. But, I mean, even in the absence of that, if he said this and she said that, if the jury believes the she said instead of the he said, isn't that the way it works?
Yes, Your Honor.
I mean, I don't disagree with you that it's far from a strong case, but apparently it was strong enough for the jury.
The argument I have as to why it's fundamental is because there is no corroborating evidence. When you go to her statement, you've got a witness who has been her friend for 6 years as the testimony, Mr. Nieves. Mr. Nieves had every opportunity to witness and see what happened. He was in a room that was in an adjoining hall, and he's facing the wall that on the other side of this wall is where this incident is supposedly taking place. She describes being pushed up against that wall. He's staring at the wall and sees nothing. She describes screaming for 2 to 3 minutes. He hears nothing. She describes being disheveled by what happened, her clothing being disheveled. He doesn't report that at all. So he really operates to contradict everything she said. In light of the lack of supporting evidence, I would argue that there's fundamental error, and I would ask for a new trial.
All right, sir. We appreciate your argument. Thank you both. Have a good day.
Thank you.